And Shelby Talcott. And Shelby, I want to start with you kind of on that point. You've been in Bedminster, you're around kind of the Republican primary and the zeitgeist of that primary. After the president's remarks last night, what were you hearing from Republican officials?
I think the big thing is, in terms of the people running against the former president, is this is just something that they want to move past. Which I think is natural because it is a no-win situation for any of the candidates running against him. They are kind of forced to walk this very fine line between, do we defend Trump because that's what the base wants us to do, or do we come out and say, yeah, look, these are really serious charges and he did something really wrong here. I don't know if I can pardon him if I become president. And so the major theme I was hearing was, okay, the day is over, we are moving on. We are continuing to campaign. Let's not talk about this again.
Well, good luck with that.
Yeah, I was going to say, did you respond? Good luck. That's going to be a great strategy. Can't wait to see that play out for you.
Always nicer than that. She would say good luck.
That's what she
Minnesota.
I know. There's a lot of Midwest.
I thought this was interesting. Let's play the sound where Trump, in his many defenses last night, talks about you can't do this. It's election interference. He is the Republican frontrunner. Here he was.
This is called election interference and yet another attempt to rig and steal a presidential election. More importantly, it's a political persecution like something straight out of a fascist or a communist nation.
Let's address the first point he made there. You can't do this. It's election interference. Because this is a criminal trial, he's going to have to be in the courtroom, right, for all of this?
Correct.
So, depending on this calendar, where it goes, what motions there are that delay things, does he have a point, at least it could be argued, that how can I be campaigning, et cetera, if I'm in the courtroom?
I think the response to that is probably rhetoric. And I don't want to say nonsense because I can appreciate his concern, but that would be his statement no matter when this investigation began.
That's fine, but looking at the facts and the calendar, they can really bump up against each other, no?
They certainly can, and I think that's one of the reasons why probably Jack Smith would like to see this happen sooner rather than later. That discovery, I'm sure, is ready to go, and after that 2-week period comes and the other co-defendant is in and they go before the judge and is arraigned, I expect that that procedure is going to move quickly as they can, but Trump's team is certainly going to try to delay it for the reasons you just stated.
Sarah, I'm interested. We've all become Presidential Records Act experts over the course of the last several weeks, because what else do we have to do in our lives? But I think what's important, and we've talked about this over the course of the last several days, it's never actually mentioned in the indictment. It is not related to this indictment directly in terms of what the special counsel put together. And frankly, it doesn't apply here because these documents that the president took were not his documents or his personal records. However, this was how the president framed things, former president framed things last night.
Threatening me with 400 years in prison for possessing my own presidential papers, which just about every other president has done, is one of the most outrageous and vicious legal theories ever put forward in an American court of law. As president, the law that applies to this case is not the Espionage Act, but very simply the Presidential Records Act, which is not even mentioned in this ridiculous 44-page indictment. Under the Presidential Records Act, which is civil, not criminal, I had every right to have these documents.
So the only thing the president said in that sound you just heard that was accurate is that the PRA is civil, not criminal. Nothing else was accurate. Why?
I mean, there's a lot there. I mean, first of all, Donald Trump's not going to go to prison for 400 years. We should disabuse him of that notion, so that's not going to happen. Secondly, if you look at what they actually charged in this indictment, they narrowed down the scope of the documents they took. I mean, we know that they took more than 100 documents with classified markings, and what they're charging him with is the willful retention of national defense information. So they have looked through all of the various things that Donald Trump took, you know, whether it was photos, whether it was notes from meetings, and they've whittled it down to what is classified national defense information that we think is actually going to resonate with the jury, that we, you know, can get the approvals on to be able to show the jury where we think, you know, we're not going to so badly compromise American national security that we can make some of this available to jurors, but where they're still going to look at this and just be horrified.
And these are the records of these agencies, not the personal records.
Yes, they're not
the
personal records of Donald Trump.
Critical piece of this.
Jeremy, the judge saying you can't talk to your co-defendant they're alleged in a conspiracy between the two, Walt Nauta. What's interesting, we'll just weigh in on that, but also the fact that prosecutors now are ordered to present a list of who else they think Trump can't talk to. And I wonder if Evan Corcoran, one of his attorneys who's also a witness, would be on that list. But he asked to talk to Evan Corcoran because he's defending him in the January 6th probe. It's very complicated.
I don't think it's so atypical to have the judge make the determination with his co-defendant. They could ultimately have a joint defense agreement and things could change, but I don't think it's that atypical. And the judge wants to ensure the integrity of this process and not run afoul of that. And we know, and we've heard from other cases, meaning in New York and just in general, that the president or former president has done these things. That list is an effort to find a compromise to the judge to make this work, that understands that the former president has a right to defend himself. He has a First Amendment right, but also weighing the balance to make sure that there is no tampering and there is no issues. And there is a concern, I think, for at least the prosecution, that there may be something on paper that says what the president or former president can't do, but no one is there in all those rooms when he is by himself, for any defendant for that matter. But it is a real concern, and that's why this has been implemented.
I think that's a really good point, because Shelby,